Judge Benitez issued an excellent decision declaring that California's ban on magazines that hold more than 10 rounds is unconstitutional. And then he issued another excellent decision saying that semi-automatic rifles, also known as, at least propaganda-wise, assault weapons, that the ban on those by California is also unconstitutional under the Second Amendment. Both of these decisions were well-reasoned by Judge Benitez, and he came to the correct outcome, in my view. But there is one technical mistake he made as to the in common use test that I really want to get geeky on in this video. It's very important you understand this, why it's good for the Second Amendment community, how it works. Very important stuff, especially if you're out there as a judge, a law clerk, or as a lawyer dealing with Second Amendment cases. Stay tuned. We're going to walk you through it in great detail in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. Obviously a book that the Israelis should have learned before disarming their civilians in that terrible Hamas attack. But we'll talk more about that down the road. All right, folks. So we know Judge Roger Benitez, or some of you refer to him as Saint Benitez, has done a great job in applying the proper law as given to him by we the people in the form of the text of the Second Amendment, and by applying Supreme Court precedent of Heller, McDonald, Caetano, and of course Bruen correctly. However, there's one area I want to clarify, and there's a lot of confusion out there that does not need to be confusion, but there seems to be some confusion among some of the judges, including Judge Benitez, and others about the application of the so-called in common use test, which allows us to determine whether or not a particular arm, not just a gun, not just a firearm, but an arm, is protected under the Second Amendment and thus cannot be banned. So I want to step back and talk briefly about this test, why it's good for us, where it came from, and then how to apply it. None of this is rocket science. You will totally get it when we're done with this video. To begin with, the United States Supreme Court has already determined two things, many things by the way, but two clear things when it comes to the Second Amendment. One is the interpretive methodology that courts and lawyers are supposed to go through when dealing with a Second Amendment challenge to a modern-day gun control law. This test, which is often referred to as the text first, then historical analog test, is an interpretive methodology. It's how to interpret the Second Amendment. And it starts off in Heller, and it was basically reiterated in Bruen in a way that made it extra easy for lower courts to apply. And one thing that Bruen did unequivocally is to say that any sort of interest balancing test, tiers of scrutiny, intermediate scrutiny, or balancing of the good of guns against the bad of guns is completely unacceptable when dealing with Second Amendment cases. 100%. That was the key difference between Bruen and Heller. So what Heller said was we start with the text of the Second Amendment. The operative language is the right of the people to keep and bear arms. The rest of it, the start of the Second Amendment, is known as the prefatory clause, which sets forth one reason for the existence, i.e., the importance of having a well-regulated militia, which basically means an effective, useful militia. That's what it meant. And the militia consisted of all Americans. All Americans were part of the militia in the eyes of the Founding Fathers. So in order to ensure that we had a well-regulated militia, the operative clause came into play. And that operative clause, of course, is the right of the people to keep and bear arms shall not be infringed. Now, before I get into how and when arms can be banned, I just want to remind you that the right of the people to keep and bear arms shall not be infringed, as we see in the Second Amendment, confirms that it is protecting an existing right. The Second Amendment does not create any rights. It codifies or memorializes or recognizes, if you will, an existing right, an existing individual right. That right is the right of the people to keep and bear arms shall not be infringed. Now, before we even talk about the history of it, I want you to pause for a moment and think. You can close your eyes if it helps, and just think about that language for a moment. And if you think about it and even write it down and look at it carefully, you will see It is clearly by virtue of the text itself contemplating a pre-existing right. Think about it. The right of the people to keep and bear arms shall not be infringed. That first part of what I just read, the right of the people to keep and bear arms, presupposes it exists. It's there. It's already there. Because then it goes on and adds the words, shall not be infringed. You see what I'm saying? So the Second Amendment, again, 100% confirms the existence of an existing right. It doesn't create a new right, which just begs the question of if ever, and this is never going to happen, by the way, but if somehow you actually repealed the Second Amendment by virtue of Article 5 of the U.S. Constitution, would it be effective? One wonders about that, if it would even count. But of course, we don't have to get into those hypothetical speculation games because the Second Amendment's not going anywhere since we now have, I believe, 27 states that are permitless carry, and we're going to add probably Louisiana in the next 6 months and likely North Carolina in the next year or so. So the number of permitless carry states are growing and not shrinking, and that's a good sign. All right, so with that sort of preliminary warm-up set forth, let's talk about when or if the government, whether it be the federal government or the state government, can ban commonly owned guns. Now, I don't want to get into like hypotheticals involving cannon, nuclear weapons, F-16 planes, any of these things. It's just, we don't need to get into that because those are not really being litigated. Those are not being litigated right now. What's being litigated that we have to win today, because we have to win the battles today, these are the important things to win today. And what are they? We know what they are. There are attempts by the anti-gun community to ban semi-automatic rifles, whether it be AK-47s, the semi-automatic versions, or, of course, AR-15 platform firearms. We understand this. And also magazines that hold more than 10 rounds or 7 rounds, which is what New York tried to do, and so on and so on. So we need to win at the Supreme Court level and otherwise these battles over the commonly owned semi-automatic rifles, AR-15s, as well as the magazines that hold more than 10 rounds. We have to win these fights. And we 1,000% should win these fights under existing Supreme Court law and the text of the Second Amendment. But how do we do that? And how did Judge Benitez reach his conclusion? And what slight error did he make that we don't want to see made again? Okay. In the Heller case in 2008, the U.S. Supreme Court was faced with an issue about whether or not the District of Columbia's ban on handguns was constitutional under the Second Amendment. The Supreme Court, in a decision 5-4, written by Justice Antonin Scalia, said that in the Heller case, that D.C. could not ban handguns under the Second Amendment. And the way he reached that was exactly doing the methodology we've talked about, which is you start with the text of the Second Amendment and ask yourself whether or not it applies to a modern-day gun control law. There it did. Why is that? Because you see, in that case, Justice Scalia and the Supreme Court defined all the relevant terms. They defined what it means to keep, which means to possess. They defined what it means to bear, which means to carry. They defined what arms meant. And arms are anything that can be used offensively or defensively. This is language from Samuel Johnson, a lexicographer who was in England, an English lexicographer from the 18th century, who, by the way, hated the Americans, but I digress. His dictionary was very important, Samuel Johnson's dictionary, and he says that arms are anything that can be used offensively or defensively, including things such as body armor. So the Supreme Court went on in Heller that says, as a textual matter, i.e. the right of the people to keep and bear arms shall not be infringed, the arms that are protected by the Second Amendment is anything that can be used offensively or defensively. And thus this court went on to say, in essence, that the Second Amendment protects prima facie, meaning at the first level, at the textual level, any and all instruments that constitute bearable arms, i.e. anything that could be used to offensively, to be used offensively or defensively in any respect. So what does that mean? So that means at a textual level, everything that you and I can think of that could be used in an arm is indeed a protected arm at a textual level of the Second Amendment. That would include knives, Bowie knives, guns, AR-15s, AK-47s, magazines, things that are essential or important to the use of firearms that facilitate self-defense or that facilitate the use of these weapons, barrels, triggers, firing pins. All of these, I think, would fall well within the text of the definition of the meaning of the word arms, textually. Okay? So at a minimum, we know that semi-automatic modern-day firearms are protected at a textual level. And you'll see why I keep saying textual, because we're going to get to the historical level in just 1 minute. Textually, in the Heller case, modern firearms in the form of modern handguns are deemed to be arms because they can be used offensively or defensively. That's a no-brainer. We get that. So textually, the handguns that were banned by the District of Columbia, whether it be pistols or revolvers, semi-automatic pistols or revolvers, are protected arms textually. Okay? So once we know the handguns are protected arms under the text of the Second Amendment, what happens? We know what happens. Because the D.C. gun control law banned those handguns, the modern-day gun control law, in that case, D.C.'s law banning handguns, touched fingers with or was implicated by or got implicated with the text of the Second Amendment, because the banning of a handgun was a banning of an arm as defined by the Second Amendment, meaning something can be used offensively or defensively, because the handguns banned by D.C. could be used offensively or defensively as an arm, and therefore it's an arm. Okay? So then what? So the Supreme Court then says, okay, well, at its first level, prima facie, it's a protected arm. You can't ban it. But what they then say is, of course, we want to make sure we get the history right, because it's text first and then history second. So they then shift the burden to the government, and they didn't do this, they did this implicitly in Heller, but they did this expressly in Bruen to say that once the text of the Second Amendment is implicated by a modern-day gun control law, that law is presumptively unconstitutional and should be struck down. That gun law should be unconstitutional and struck down presumptively. However, there is an opportunity for the government to come forth, and the government bears the burden of proof. They bear the burden of coming forth with historical analog laws to demonstrate that there is a long-standing tradition in American life of restricting or banning the gun in the way that the modern-day gun control law exists. So the example I like to give conceptually, because I think it's an easy concept, is if you had gun control laws in 1791 that said you can't use a gun to commit murder, and that is the law, or those laws existed through today, which they are, you can't use a gun to commit murder. If you are convicted of murder or you've murdered someone in cold blood, you're not allowed to assert a Second Amendment defense. So you have a right to keep your arms. Therefore, I have the right to murder my wife. No, because going back to the founding, historically, there are historical laws that would prevent you from committing murder with a gun from the time of the founding through today. So that's a long-standing traditional restriction on your use of a gun, i.e. you cannot use your gun or your arm to commit cold-blooded murder. It wasn't allowed at the time of the founding, hasn't been allowed ever in American history. That's a sort of long-standing tradition that the Supreme Court will be looking for to see, does that kind of thing exist? And if it doesn't exist, the government loses and the modern-day gun control law is struck down as unconstitutional. So here, what did the Supreme Court do in Heller? So the Supreme Court says, and this is why they did all the work for gun ban cases and why courts like Judge Benitez don't actually have to do that much work, even though a lot of them are doing it for a bunch of reasons. The Supreme Court looked at every conceivable law before America's founding, during America's founding, after America's founding, even after the 14th Amendment, to see if there's any conceptual basis for banning a type of arm in American life. And they only found one long-standing kind of law going from England through today, and that is that there's a tradition of banning the carrying of dangerous and unusual weaponry. Okay? And they said, as a consequence of that historical tradition of banning the carrying of dangerous and unusual, conjunctive, not either or, dangerous and unusual, they said that's the only conceivable thing that might possibly be allowed to be banned under American law. Then they went on to say, here, handguns are today in common use by Americans all across the country, and therefore it is impossible for handguns that DC is banning to be dangerous and unusual, so the government may have created the standard of dangerous and unusual, but they can't meet it with this handgun because we measure what's popular today, and the American people overwhelmingly choose handguns for self-defense. It's in common use by Americans for lawful purposes, including but not limited to self-defense. Therefore, it cannot be dangerous and unusual, and you cannot ban handguns. That is the interpretive methodology of text first and history second, and in the context of banning arms such as handguns or down the road AR-15s or magazines, that text first and historical analysis second approach to interpreting the Second Amendment gave rise to a test. That test for dealing with arms bans is either, you can call it either the dangerous and unusual test, meaning the government bears the burden to show that arms they're trying to ban is dangerous and unusual, or the flip side of that is they have to demonstrate, the government has to show that the arms they're trying to ban is not in common use by Americans for lawful people, for lawful purposes, I mean, right? That's the standard. And today, in today's fights, the ones we're dealing with today, dealing with AR-15s, AK-47s, and magazines that hold more than 10 rounds, it is 1,000% clear that the government simply cannot meet the burden of showing that these weapons, these arms, are not in common use, i.e. they're dangerous and unusual. Now, but again, the in common use test or the dangerous and unusual test, which is derived, it is derived from the text first and historical methodology, historical analog second methodology. It's derived from that. So every time going forward we're dealing with an arms ban case, you simply have to apply Heller's text, then history, and of course the Supreme Court's already looked at all the historical analogs for banning arms because they had to do it with the DC arms ban case dealing with handgun bans, and they came up with the dangerous and unusual test, or the flip side being in common use, because if something is in common use, it cannot be unusual, and thus it cannot be dangerous and unusual. Government cannot ban them. That's why it's such a great test, because if you applied it correctly, you cannot ban, the government cannot ban AR-15s, they cannot ban semi-automatic pistols, they cannot ban magazines holding more than 10 rounds, and so on and so on. You can't do it. They're in common use. So this is why it's such a great test. Now, what was the mistake that Judge Benitez made? The good news is it did not affect the outcome, but it's a mistake we don't want to see made again. Remember, I explained to you that once the text of the Second Amendment implicates a modern-day gun control law, the burden shifts to the government to come forth with historical analog laws. What Judge Benitez did, which is a no-no, and he did it twice. He did it both in Duncan versus Bonta and in Miller versus Bonta. He took the in common use test, or the dangerous and unusual test, they're sort of flip sides of the same concept, right? And treated it as part of the textual analysis. He elevated it to the textual analysis and said that as a matter of textual analysis of the Second Amendment, arms, as in the right of the people to keep and bear arms, equal those things that can be used offensively and defensively, and which are also in common use by Americans for lawful purposes. You see what I said? See the mistake? He elevated the historical part of in common use, dangerous, unusual to the textual level, and thus said that because AR-15s, magazines that hold more than 10 rounds, are arms that can be used offensively or defensively, and are also in common use by Americans, as a matter of text, they are protected arms under the text of the Second Amendment. This is wrong, and this is potentially bad. Why? Why? Because again, you're helping the anti-gunners. It's a mistake that helps the anti-gunners. How so? Remember, once the text is implicated, the burden shifts to the government. At the textual level of the Second Amendment, when you're fighting about the text and does it apply to a modern gun control law, the burden really is borne by the Second Amendment plaintiffs, those that are asserting Second Amendment rights. So you want to minimize the burdens that you put on the Second Amendment plaintiffs and maximize the burdens that you put on the government. So by Judge Benitez elevating to the textual level, the in common use inquiry, he basically shifted the burden wrongly from the government to the Second Amendment plaintiffs. That's bad and wrong, because that's not what the Supreme Court did either in Heller or Bruen. At a textual level, any arm, which is anything that can be used offensively or defensively, textually cannot be banned prima facie. That's the presumption. Then the burden shifts to the government, and the government bears the burden to show that arm, magazine, AR-15, AK-47, whatever, that arm historically can be banned, but they can't possibly do that under the dangerous and unusual test. Or again, the flip side of that is in common use. Because again, if it's in common use, it cannot be dangerous and unusual because it cannot be unusual. So you see what I just did? The burden on the historical part of the analysis is on the government. We always 100,000%, and the Second Amendment community want the burden to shift to the government to prove something. Put the burden on them. Make them do the work. Just like in a criminal case, the burden, you are presumed innocent. The burden of proof is on the government to prove that you did the crime. Same concept. But Judge Benitez made this mistake by conflating or combining the in common use historical part of the Second Amendment analysis and he elevates to the textual level. This is very bad and a no. Now, the good news is, in the context of this case of magazines and AR-15s, the reality is it shouldn't matter because they're ubiquitous. Everyone has these things. There's 100 million magazines plus that hold more than 10 rounds. There's tens of millions of semi-automatic rifles. So really, at the end of the day, it shouldn't matter to the outcome. Nevertheless, you never want to give the government any benefit of the doubt when you don't have to and when it's wrong. And I'm not beating up Judge Benitez here. We love Judge Benitez. He does a fantastic job. His opinions are fantastic and great. Nevertheless, it is my job here at the Four Boxes Diner, as I see it, to flag things, good and bad and ugly, and even when friends of ours, people we like, people we cheer for, even when they make mistakes, we have to call them out. We're not calling them out to be mean or nasty, okay? We're calling them out so it's a mistake that does not get repeated, because we've talked about how legal cases are precedents. They're brick by brick by brick. They build on and other people rely on them. Other judges will quote and rely on Judge Benitez. So we do not want other judges in America to conflate the text of the Second Amendment with the historical analysis the way Judge Benitez did, because that can come back and bite us on the butt, and we don't need to give the government those added advantages. So, okay, so the bottom line is text first, historical analog second. The in common use test, dangerous, unusual concepts are the test for arms ban cases. The burden shifts to the government. The burden is on the government to show that whatever they're trying to do in terms of arms bans, whether it be a butterfly knife, a brick, a billy club, a handgun, a rifle, a magazine, a firing pin, a barrel, whatever. And yes, short barrel rifle and short barrel shotguns. Yes, indeed. All that burden goes to the government to show these are not in common use, and thus, by extension, they're somehow dangerous and unusual. But again, in the modern era, this is a fantastic test for us. We must embrace it. For those of you who say there's going to be problems down the road, we will deal with that down the road if we get there. But if we don't protect our magazines and our AR-15s and our AK-47s, there will be no down the road of anything else. So you got to start with winning these battles now. These are very important for us to win. We should be able to win, and I hope we do. And so there you have it. All right, folks, hope it wasn't too inside baseball today. Hope you learned a little bit something here at the Four Boxes Diner. Make sure you subscribe, like, and share this video. And don't forget to follow me on X at Four Boxes Diner. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.